Commercial law examination. Question 1. Spinner Limited processes raw cotton into cotton fabric at their factory in Yorkshire. The cotton fabric is then supplied to various manufacturers around the UK. Spinner seeks your advice on two recent problems. On the 1st of March, Spinner contracted to buy 100 tons of raw cotton from importers Fibre Limited, who are based in Liverpool, at a price of £150 per ton. Delivery of the total order was to take place by the 1st of April. Spinner required the cotton by this date to process it into fabric and fulfill customer orders on the 8th of April. On the 21st of March, Fibre delivered 70 tons of cotton to Spinner's factory. Spinner demanded the other 30 tons and were told they would be delivered at the contract date of the 1st of April. Spinner insisted that Fibre failed to deliver any cotton. On the 4th of April, without contacting Fibre, Spinner bought 100 tons of raw cotton from an alternative importer, paying the market price of £175 per ton. On the 5th of April, Fibre Limited attempted to deliver 100 tons of raw cotton, but Spinner refused to accept delivery. Spinner and Fibre are both claiming the other party has breached the contract. In a separate contract, Spinner agreed to purchase a new computerized weaving machine from Weaver Limited, a company based in Manchester, for £50,000. Spinner requested various modifications to be made to Weaver's standard machine to make it more efficient for weaving cotton. The contract between the parties was made on Weaver's standard terms and conditions, which Spinner did not read or negotiate. One of the terms stated that Weaver Limited's liability for the product supplied is limited to replacement or repair, and hereby expressly excluded. The machine stopped working 3 weeks after purchase and was unusable. Weaver offered to examine and repair the fault. Spinner agreed to the repair, and Weaver supplied a replacement machine free of charge while the repairs were carried out. The repaired machine was redelivered to Spinner Limited, but 3 months later developed the same fault again. Spinner Limited now wants to reject the machine. Advise Spinner Limited on their legal position and any potential remedies they may be entitled to in both incidents. Incident 1. Dispute with Fibre Limited. Key issues. Whether Fibre Limited breached the contract by delivering only 70 tons of cotton by the 21st of March. Whether Spinner Limited was entitled to reject the entire delivery and purchase substitute cotton from another importer on the 4th of April. Whether Fibre Limited breached the contract by delivering the full 100 tons later on the 5th of April. Analysis. Delivery obligation under Section 29, subsection 3 of the Sale of Goods Act 1979. Time of delivery is a critical term if agreed upon. Fibre was obligated to deliver 100 tons by the 1st of April. Fibre partially delivered 70 tons on the 21st of March, with the remaining 30 tons promised by the contractual delivery date, the 1st of April. Fibre did not technically breach the contract, as the deadline had not yet passed when Spinner demanded the remaining 30 tons. Repudiation by Spinner. Spinner's refusal to accept Fibre's performance on the 5th of April may constitute a breach if Fibre's tendered performance was within a reasonable time frame, particularly if time was not of the essence. Time is of the essence if it is explicitly stated in the contract or can be implied by circumstances like Spinner's reliance on delivery to meet customer commitments by the 8th of April. Spinner's rejection of Fibre's final delivery and substitute purchase at a higher cost could make Spinner liable for unnecessary additional costs if Fibre is deemed not to have breached the contract. Mitigation of loss. Spinner acted unreasonably by not notifying Fibre about the substitute purchase. Failure to communicate breached Spinner's duty to mitigate losses and may reduce damages recoverable from Fibre. Potential remedies against Fibre Limited if time was of the essence. Damages for late delivery or non-delivery under Section 51 of the Sale of Goods Act to cover additional costs incurred, such as a £25 per tonne difference for the substitute cotton. Liability to Fibre Limited. If time was not of the essence, Fibre could claim damages for Spinner's wrongful repudiation and refusal to accept delivery of the contracted cotton on the 5th of April. Spinner's case depends on proving that time was of the essence or Fibre's delay frustrated Spinner's business obligations. Incident 2, faulty weaving machine. Key issues: whether spinner can reject the machine after accepting a repair and replacement machine, whether the exclusion clause in Weaver's terms limits spinner's remedies, whether Weaver Limited breached implied terms under the Sale of Goods Act. Analysis: breach of implied terms. Under Section 14, subsection 2 of the Sale of Goods Act, goods must be of satisfactory quality. Under Section 14, subsection 3, goods must be fit for their intended purpose if the seller is aware of the purpose. A weaving machine that becomes inoperable within weeks breaches these terms. Spinner's request for modifications may imply reliance on Weaver's expertise to meet specific requirements, further emphasizing fitness for purpose. Exclusion clause. The exclusion clause limits liability to repair or replacement, excluding rejection or further remedies. Under the Unfair Contract Terms Act 1977, such clauses are subject to the test of reasonableness. Limiting liability for defective goods, especially in a business-to-business transaction, may be deemed unreasonable, particularly given the repeated faults. Rejection rights. Under Section 35, subsection 6 of the Sale of Goods Act, a buyer can reject goods after accepting them if the defect reoccurs or persists. Spinner's initial acceptance of repair does not preclude rejection if the machine continues to fail. Potential remedies against Weaver Limited: reject the machine under Section 35 and claim a full refund, claim damages for breach of statutory terms on satisfactory quality and fitness for purpose, argue that the exclusion clause is unreasonable and therefore unenforceable under the Unfair Contract Terms Act. Weaver's offer. If rejection is successful, spinner may not have to accept further repairs or replacements, but could recover damages for additional costs incurred due to machine downtime. Conclusion: Incident 1, raw cotton contract spinner may recover additional costs if time is of the essence and Fibre breached the delivery term. Fibre could counterclaim for spinner's refusal to accept delivery on 5th April if time was not of the essence. Incident 2, faulty machine spinner can likely reject the machine and seek a refund under the Sale of Goods Act and the Unfair Contract Terms Act. The exclusion clause is likely unenforceable due to unreasonableness. Spinner Limited should focus on evidence supporting their reliance on delivery dates for Incident 1 and the machine's repeated failures for Incident 2 to strengthen their claims.